welcome to Macros with Mythili, the ET Now show that takes a hard look at all the major macroeconomic issues and developments in India and overseas. Well, it's a truism that justice delayed is justice denied. But justice delayed is not just justice denied, it also has a huge economic cost. Economic cost that cuts across the lines and affects all of us, ordinary citizens and businesses alike. Over the years, few have questioned the state of affairs. It is only now that eminent lawyers like Harish Salve and ministers like Nitin Gadkari are talking about the economic cost of judicial delays, with Salve going so far as to say the slowdown began with the top court's judgment in the 2G spectrum case in 2012. The apex court, according to him, knocked out billions of dollars of foreign investment with a stroke of its pen with its judgment on 2G and the coal block allocation cases. He estimates the cancellation cost at about 1% of GDP, and that's a huge cost. Gadkari was no less explicit. Court orders, according to him, had delayed projects and had led to contractors claiming thousands of crores of compensation from the government. How do we remedy the state of affairs? Are our courts overburdened? Does the judiciary not understand the time value of money? To discuss the reasons for the impasse and the possible remedies, I have with me a panel of three experts, a lawyer, an academic, and a corporate honcho to give you a 360-degree perspective. So let me welcome to the show R.K. Sengupta, founder and research director, Vidhi Center for Legal Policy, Mudit Kapoor, professor, Indian Statistical Institute, New Delhi, and Mohandas Pai, former director, Infosys, and currently chairman, Manipal Global Education. Welcome to the show, all three of you. We all know the data of pendency of cases in courts, of how more than half the 8 million cases pending in the high courts have been pending for more than 3 years, and how the position is much worse in the lower courts and so on. So would you agree that this is now becoming a major obstacle in the path of economic progress? Or is that an exaggerated view? Let me start with you, Mr. Pai, because you no doubt have been at the receiving end of many of these delays. We'll go into the reasons and remedies a little later, but for now, a brief opening comment. Mohandas?
I think the lack of justice in this country, lack of effective justice has been a bane of our society for the last 70 years. And as far as business is concerned, if you look at all rankings globally and within the country, the lack of settlement in commercial contracts, the delay in the justice system is hurting everybody. And today in business, a perverse thing has happened. If you don't fulfill your contract, the other party will come and tell you, go to court. They love going to court because in the court they can dilly-dally for the next 5, 10, 15 years. And courts dilly-dally. And two, when there are large amounts involved, like in the 3G case, like in the coals case, like in the Goa mining case, like in the environment cases, etc., the courts take their own sweet time, and when they give the judgment does not reckon with prior rights. They do not look at all the parties. They do not look at the impact of what is going to happen, because commercial decisions are not as easy as enforcing somebody's fundamental rights. And I think this has been one of the biggest problems for India to be competitive. And there's a distinct lack of trust in the justice system in this country. Look at tax cases. You go to the Supreme Court 3 to 5 years, High Court 7 to 8 years, and money is stuck. The income tax department extorts money from you and takes away the money. They're very happy because they met the target. But for businesses, it is a nightmare going to court. And the taxman gets away with passing perverse assessment because they say, go in appeal and you'll win in appeal. And they know that government will appeal and it will go on and they will be off the job. So I think across government, across parts of industry, the failure of the justice system has imposed a very, very high cost and made India uncompetitive to a very large extent.
Arya, contracts are the very basis of any kind of commerce, as we know, all over the world. But at the same time, what we see is that when it comes to enforcement of contracts, India's position is 164 out of little over 170 nations, greatly adding to the cost of doing business, even though in ease of doing business we're much better. And this has made us much less competitive in global markets. Individuals too are not immune. We've seen that all of us have to deposit a much higher security fee with a landlord when we rent a house, because he knows that there's a possibility we might not vacate when the lease expires. And if he goes to court to enforce a contract, it may take donkey's years before he gets a decision. So should we hold the judiciary responsible for the kind of slowdown we're seeing, Arya?
It's a complicated question. I think the judiciary certainly has to bear part of the responsibility. Society has to bear the great part of the responsibility, and the government has to bear some part of the responsibility. I'll quickly elaborate on each of these. I think as a society, we are in a position where we are transitioning to a rule of law state. We are not a rule of law state yet. So the example you gave around the tenancy contract, It's because we have an imperfect understanding of the rule of law that we have to pay this higher security deposit, because everyone thinks that this may not get enforced. So I think societally we are just comfortable doing things on the basis of interpersonal trust rather than on law. As far as the government is concerned, I think the government bears a part of the responsibility, because there is no litigation impact assessment that is done before every law is passed. Do we know how much it's going to cost to enforce a particular law? Take the example of the bankruptcy code, for example. Do we know that how much it's going to cost for the bankruptcy code to get implemented? How many authorities do we need? We need to do a litigation impact assessment, which is not done. And thirdly, for the judiciary, I noted in your introduction you spoke about what Mr. Salve had to say about the 2G case. I think the judiciary as an institution is better equipped to deal with micro issues of justice, that is justice between the two parties that come before it. I think the judiciary as an institution is ill-equipped to think about the larger systemic effects of giving justice across the board. So in terms of how much staff we need, in terms of whether to give an adjournment or not to give an adjournment, which you succinctly summarized as saying the time value of money. I think this is something that the judiciary needs to get its act together on, because it's not just a question of micro justice, it's a question of macro justice, that's speedy and effective justice for all, and not just the parties before the court.
Okay, I couldn't agree with you more, Wargya, and I hope the judiciary is listening to this very carefully. But Mudit, academics are supposed to be impartial, to go only by evidence, and you've done a lot of work in this area. What does the data show? Can we attribute the slowdown to judicial delays, Mudit?
Well, the direct empirical evidence when it comes to judicial delays, or I would say in general judiciary, in terms of economic growth and economic slowdown, is very limited right now. But I'll give you some evidence. We've looked at the performance of the Supreme Court under different tenures of CJI. And what we found was that if you look at the period from 1990 to 2010, there was an increase in the productivity of the performance of the Supreme Court, which is in terms of the number of judgments per day being delivered by the Supreme Court was much higher compared to the rest of the period. And this was also the period when India has actually grown. So from 2010 onwards, unfortunately, it is the number of judgments passed by them on a daily basis has slowed down. And that's also the time period which is associated with economic slowdown. But these are associations in some sense. But I think in the common law system, the judicial system plays a very important role, which is not only does it apply the law to the facts of the case, but it also promulgates a particular rule of law. It interprets the law. And I think it is in this area one has to be very cautious, which is that they shouldn't just merit who is right and who is wrong, but the rule of law, whether that will be an intelligent one or not. So at 2010 onwards, there have been several cases where it was not that there was a judicial delay. Actually, there was a judicial hurriedness in certain cases to pass judgment, which have caused a lot of confusion in the economy. And you cited the 2G case, but also the coal scam. This is very significant because within a matter of days, you cancel all coal allocation from 93 to 2013 or 2012. That posed a huge constraint on the economy because the power sector, which relies on coal, the bank credit exposure grew from less than 1% in mid-90s to almost 20% by 2012. So when you're talking about just canceling the allocation, you have to also worry about the investors, the creditors, the people who are employed in this sector as well, because those guys perhaps did not know that all these allocations are actually they were wrong, or it was there was something going on in terms of violation of the law. So just the opposite of what we started, but I think both delays and hurriedness to pass judgment, we have to be careful that is it an intelligent judgment or not.
Mohandas, if you were to single out the 2 or 3 main reasons for the delay, what would they be?
I think the real reasons for the delay is, one, I don't think the courts look at commercial disputes in a manner where there is a sense of urgency like they do for PILs. For PILs, they want to hear it fast and give orders, and for commercial disputes, they take their own sweet time. Second, they give stays on many commercial matters without appreciating the consequences of the stay. And once a stay is given, the matters keeps pending because there is no resolution. The other parties got immediate, let's say, relief, and they are not bothered. And the third, the gravity of the situation and the amounts involved are something that the courts must appreciate, so they will hasten up. For example, Justice Nariman in the IBC cases is taking a very strong step to make sure decisions are given in time, which is very good. The attitudes have changed. So the understanding, the attitude and the impact of what is happening is something the courts need to appreciate even more.
But Arge, you talked about the IBC. So let me take the concrete example, in fact, of the IBC, the Insolvency and Bankruptcy Code. The main objective of that was speedy resolution of stressed assets. But what we are seeing time and again is that deadlines have no meaning for courts. As against the original deadline of 270 days, we've seen cases drag on for more than 700 odd days. Not only have different tribunals given contrary ruling, the Supreme Court too has muddied the waters. For instance, the code is quite clear, as you talked about the waterfall, about operational credits ranking creditors, ranking after financial creditors, but the Supreme Court hasn't gone by all this. So what is the meaning of having a code in the first place?
Yeah, I think that the IBC is a good example to take up because the law is as clear as it gets in terms of setting up a new mechanism to deal with stressed assets. As far as timelines are concerned, I think the judiciary has always had a sort of frosty relationship with timelines. It's unfortunate. But the judicial system is such that we know as lawyers that the first thing you go and ask for is condonation of delay, and condonation of delay, as long as you can show some reasonable cause, is typically granted. So the fact is that if 270 days is provided for, 270 days must remain the law, and whether it is in SR Steel or whether it is in any of the other judgments of the Supreme Court and the NCLAT, I think there is no place for equity or fairness or general considerations of that nature, which are by their very nature subjective and discretionary, to play any role when there is a fixed timeline given. If the timeline doesn't work, then perhaps the court should recommend to Parliament that it amends the timeline, so we have a more workable timeline. But the fundamental imperative of the rule of law is the interest of certainty. And I think it's critical that certainty is achieved at all costs. A related point, which is what I ended with, costs. Costs orders are common the world over. If parties are delaying or if parties have filed litigation where they have lost, then they must bear costs of the other party. Now, this is something that happens very rarely in India. And I think the Supreme Court as well as the High Courts need to get their act together as far as costs orders are concerned, because one way to discourage litigation is by ensuring that costs orders are passed. Of course, exceptions can be made for cases where the person is indigent or whether there is a reasonable cause. But otherwise, costs orders are necessary to prevent delays. Timelines must be followed, and if the timelines can't be followed, then a recommendation must be made to Parliament to amend those timelines, because otherwise they make no sense.
Oh yes, that's an excellent suggestion, Arge. The problem in India is that we're tolerant about all the wrong things. We're tolerant about delays, we're tolerant about being unpunctual, we're all the wrong things, and intolerant about all the right things that we should be. It's just the reverse. But Mudit, as in much else, is there a geographic divide as far as judicial delays are concerned? Are they more pronounced in some parts of the country, like in the eastern and central India, as compared to the south and the west? Do we see that better efficiency in these parts of the country, which are normally better than the others?
So we analyzed the data from the National Judicial Data Grid, which has become public for some time now. And what we saw, for example, in the land reference cases, there's huge geographical variation. So Punjab, for example, a land reference case could last for 4 years, but you could have a state like Goa, Bihar, Uttar Pradesh, where it would be more than 10 years. So naturally, there is a geographical divide, but it's not so stark as north and south, but it differs from state to state. In fact, we found something very fascinating, that at one end you have Rajasthan, which has initiated labor reforms, but the number of labor cases in Rajasthan is also extremely high. So at one end you have labor reforms, but number of cases taking to settle, time taking to settle these cases is also very high in Rajasthan. So it could negate the entire effect of labor reforms to a certain extent. So in some sense, there is a huge geographical divide, but it's not north, south, east, west. Goa, for example, in land reference cases has a very high, it takes a long period of time to dispose those cases. But southern states, on an average, are better off than the northern states, particularly UP and Bihar. I think one has to look at the judicial system very carefully in these two states. And as Aragya talked about the rule of law, once you have a judicial system in which people don't have much faith, then there are larger questions of rule of law which have a direct impact on economic growth.
Let me just interrupt you there because I'm afraid it's time for us to slip into a very short break. But please do stay with us. We'll be back very soon. Welcome back. You're watching Macros with Mythili, and I'm in discussion with three experts on the economic cost of judicial delays, something that has completely escaped below the radar so far. Mohandas, you spoke about the IBC case, and I'm not sure many IBC lawyers would agree with you on the fact that actually the courts are now, cognizant of the kind of time value of money. In fact, there I would also disagree with you. But apart from the policy flip-flop, which is bad enough, in addition, investors in India have to deal with Supreme Court decision, like as you mentioned, the cancellation of 2G licenses, coal block licenses, etc. Have such decisions really deterred foreign investors, as Harish Salve has alleged, or is it that not only foreign investors but even domestic investors are kind of deterred by this? What would you think? Is the impact worse for foreign investors?
The impact is worse for foreign investors because they're outsiders. They're used to a Western system where disputes take 2 or 3 years to resolve. They know that in commercial matter there could be dispute, but the expectation is that it will take 2 or 3 years and the matter could be dissolved. And in the overseas countries, many of them choose to settle. They go to the court, and before the trial happens, the decision is taken. They will choose to settle and close the matter because they want to get on with their lives. Even in regulatory matters, they will choose to settle and pay a fine without admitting anything and go on. So they're used to that kind of a culture, which is a very mature culture. Whereas in India, the settlement process, except for SEBI and some matters, is not very mature. Other party likes to prolong it. And the courts, the proceedings get delayed. It gets delayed because people see adjournments, and the courts don't enforce the view that things are urgent, it has to be done. I don't think the courts appreciate the time value of money. They look at it from the justice point of view, but commercial contracts have to be looked at slightly differently.
Argi, given the fact that judicial delays are something that we seem to have to live with, you would have thought that alternatives like out-of-court settlements, mediation, etc. would be a much better option. But these don't seem to have taken off in India. Why?
Because it ultimately ends up in court. So the point is, the idea of a mediation or an arbitration is that you will get speedy justice from an expert body and you are not expected to litigate further. But the fact is that routinely Section 34 matters, which is challenging an arbitration award, are filed before district courts and high courts in the country. So I think the blame for this has to lie solely on parties. As in, if parties do want to choose alternate dispute resolution methods, then this cannot be another step in the ladder which ends up in the Supreme Court. As in, it has to stop there. And I think the parties also need to have that level of discipline to not want to challenge this in court. At the same time, courts must also be loath to interfere in arbitration awards that have been passed in matters that parties have voluntarily agreed to go to arbitration. Now, some courts like the Delhi High Court statistically are better, that they don't interfere in arbitration awards typically unless there is some public policy reason of fraud or some such thing like that in order to interfere. But most courts are not like that. And so I think it's the reason as to why ADR mechanisms, despite their tremendous promise, have not really taken off in India is because of the fact that everyone knows that they can have their day in court and the court is willing to give them that day. So I think the court also needs to ensure that if there is an award which is not flawed, then it doesn't interfere. Parties also need to know that they've got a good award from parties, from the arbitration tribunal, and they need to stop it there.
Okay. Muthu, in the course of your research, have you examined the performance of fast courts, specialized courts, tribunals, and have they made a material difference as far as dispensing justice speedily is concerned?
Must admit, I have not been able to examine at a very specific level the performance of lower courts. The data on this is extremely difficult to get. So unfortunately, I don't have much empirical evidence on this front.
Is poor drafting partly responsible in that it gives the courts room to interfere? In the case of IBC again, which we keep talking about, why should there be any uncertainty really whether the provisions of the PMLA, the Prevention of Money Laundering Activities, override IBC or not? I thought the IBC code is pretty clear, but courts are still interpreting and reinterpreting that.
No, I'm talking about the distribution of proceeds between unsecured creditors and secured creditors. Now, the law is very clear, as far as I know, that it is the committee of creditors which decide. Now, suddenly we have a judgment to say, what are you doing about this, etc. And now it's gone to Supreme Court, and the Supreme Court has just said there is a question of equity, etc. When the law, I think, is very clear. Now, there is a tendency in many courts, even the lower levels, to extend the law. I mean, there's a very larger issue within this country, and I think the courts, in most of the courts will try to extend the law, apply principles, and try to give, relief where on the plain reading the relief may not be justified, and extend it to other areas. And there too there is judicial activism. So there are a large number of issues, and I think the key issues have to be settled. It can be settled by specialized benches of Supreme Court on commercial matters where deep expertise can be applied by justices who look at this court day in and day out. It can happen in the high courts where tax benches are heard. So I think that the need for the courts to look at special benches which will focus on economic matters, commercial matters, tax matters, so the deep expertise is there and relief can be given early and not clubbed along with all other cases.
Would you have any evidence? And related to that, another question that I wanted to ask you is it how much of the responsibility for these delays lies with poor drafting? And is that what gives courts room, to interfere and give their own often conflicting interpretations? Arghya?
Yeah, so the drafting is poor in part. I, however, would resist the temptation to blame it on poor drafting, because no matter how well the law is drafted, there will be room for interpretation, there will be room for lawyers, which means we will need judgments of courts. So yes, there is room to do better as far as drafting is concerned, but to say the reason for, or one of the key reasons for judicial delays is poor drafting would be missing the wood for the trees. Regarding special courts, as in we had a study as far as special courts are concerned, and we found that generally insofar as special courts in criminal matters are concerned, that they are largely not making a difference, because what you're essentially doing is that you're designating an existing court as a special court. So it's really not a special court in that sense. It's just a regular judge who suddenly now becomes anointed a special court judge. That's number one. As far as tribunals are concerned, as in we can't think of tribunals as a one-size-fits-all. There are many different kinds of tribunals, some which replace the jurisdiction of the High Court, some which are lower than the High Court. But overall, and I know that this might be a bit of a simplification, and I'm making it advisedly, overall, I think our experiment with tribunals has woefully failed. We don't have specialized dispute resolution. There are generalist judges and bureaucrats who are sitting on tribunals who don't have specialized knowledge in that particular area on generally, number one. Number two, tribunals take quite long in their decision making, so it's not as if they are quick and expeditious as we had expected. And number three is that parties regularly appeal those matters to the regular judicial system. Courts have also said that there can be a 226 petition filed before the High Court as well as a 136 before the Supreme Court. So tribunals are not giving final verdicts. So I think our experiment with tribunalization has failed. We should really look at capacity building within our judicial system rather than ad hoc solutions like tribunals.
Mohandas, you spoke about specialized benches, but the experience with the NCLT in the case of IBC again has not been very great. In fact, faced with constant delays, government has reportedly sought the Supreme Court's approval to frame rules to make the judges of the NCLT accountable for delays in disposing of cases. This is the first time that the government is in fact contemplating something like this. But can this stand in a court of law, Mohandas?
I think they can stand in a court of law because, the important thing in a court is to give justice. And if there are delays because of procedures, the government can change the law to have a different kind of procedures. And I'm sure the Supreme Court also will help, because justice is denied, justice is delayed. That is the problem. The other issue also is, Mythili, is the lack of capacity. I'm sure if you look at data on the IBC cases, we need many more courts. Maybe we meet 2 or 3 times courts, and the government is not doing its bit by investing inadequately in justice system. We only have 18 judges per million people. America has 100. We need 50 as per the law commission, but government should invest. Government should make sure more hiring is happen. It's only the Modi government which has made sure for many years the Supreme Court has its entire complement of 33 judges. Now the Supreme Court should have maybe 50 judges to take care of need. So judicial capacity assessment is required every 5 years. We must build up capacity because a large part of the year the courts don't hold sittings. Sittings are also narrowed, and let us admit it, court work is a tough work for the judge. It's a very tough work. It's not easy work. For 5 hours of court work, maybe you must do 10 hours of work outside to write judgments, to read and do everything else. So we need to build much more capacity in the system.
Okay, that's not a very happy note on which to end the discussion, but I'm afraid we've run out of time completely. So thank you so much, Mohandas, R. and Mudit, for joining me in the discussion. Hopefully, we have succeeded in setting the ball rolling on a subject that most of us have preferred to brush under the carpet so far. Thank you also for watching. Remember, we'll be back next week with yet another edition of Macros with Mythili. Till then, it's thank you and goodbye from all of us at ET Now.